charges or failure to appear or unpaid financing. So
Okay.
please just ask the court to advise what the status is.
The status is this is a new arraignment. It was written, this is a warrant that was issued while she was not in custody. The case is from 2024. So this is a first look.
Yes,
Excuse me.
Yes,
Can
ma'am.
I say something? Which charge is this? Because
I can tell you. That's not a problem. This is, where'd you go? Ma'am, in this case, it is alleged that on or about March 25th, 2024, in the city of Pontiac, that you allegedly engaged in a violent or tumultuous manner, jostled and pushed LaDaisiana Wright. The charge that you were charged with is a disorderly person. It is a misdemeanor, punishable by 90 days in jail and or $500. As it relates to that, I'm going to ask your lawyer how you wish to proceed with that case. This is just an arraignment, so I'm just going to tell you your charges and set a bond and give you a new date. Mr. Hess.
Yes, thank you. Ms. Samples, please not guilty and requesting a court-appointed attorney.
Okay. I'm going to enter a plea of not guilty, ma'am. I'm going to appoint court-appointed counsel. In this case, ma'am, your judge is the Honorable Judge Whley.
Okay.
Okay. And then give me 1 second.
Okay.
Yes, ma'am.
Interpreter for.
Oh, okay. Thank you. That's for, okay. Judge Whley will next hear your case, ma'am, on Monday, Wednesday, Friday. Let's see what the 23rd looks like. It's got a trial. June 23rd.
Will I be in custody or will I be released?
Ms. Samples,
Because-
let me get to the rest of it. Court hasn't made a decision yet.
This is my first time ever being in jail.
Okay, so I'm going to go through, and at the very end, I'm going to answer all questions you may have, okay? But your next court date is June 23rd, 2025. That's going to be at 9 a.m. on Zoom. Ma'am, we have an address for you of 31 Karen Court, Apartment 2. Is that still a good address?
Yes, but it's court 2, not apartment 2. The apartment is actually 31.
So it's Court 2, Karen Court
Yes.
2, Apartment 31?
Yes.
Okay. It's still 48340 though, right?
Yes, ma'am.
Okay, then can the court have a phone number?
Yeah, 248
Uh-huh.
636
Uh-huh.
5126.
Okay.
That's my personal one.
Okay. That is the phone number that the court-appointed counsel is going to get in touch with you to talk to you about your case the day, before you go to court next. And then that address you gave me of 31 Karen Court 2, number 31, is where we're going to send your court notice with the Zoom instructions, okay?
Mm-hmm.
Okay, now we're going to talk about bond. As it relates to bond, pretrial services?
Thank you. The defendant was interviewed. Her information is verified by her mother, Christina Jackson. She's a 27-year-old single female with 1 5-year-old child, indicated living with her parents at the state of duress for the past 7 months. She came into custody on allegations of a new drunk driving. She came in on Saturday, June 7th. She's released pending investigation on that matter. She does have a civil infraction warrant out of 48th District Court, but beyond that, no other history of failing to appear, no history of violence, and is before this court what's considered a nonviolent misdemeanor charge. Given that information, we are recommending release on her cognizance with the conditions of no alcohol or controlled substances and no return to the location of the incident, being the Vogue nightclub at 25 South Saginaw in Pontiac.
Okay, thank you. Defense?
I agree with the recommendation.
Okay. Court is going to impose a $500 personal bond. Personal bond means you don't have to post any money, Ms. Samples. But if you don't come to court, you do not have to post any money. They will release you. However, if you don't show up to court and you come back, don't look for a personal bond. Are we clear?
I'm coming.
Okay.
I'm
So,
coming.
hold on. Let me,
Oh my God, y'all gonna make me cry telling me all this.
don't
good
do
stuff.
that. Don't do that. Okay, so, you've got your bond. It's personal, so they should release you today. June 23rd, 2025, 9 a.m. on Zoom. Okay? So you should be all set, Miss Samples. You can
What about
stand.
the civil infraction? Do I pay that? Because I could have swore I paid that last year. I paid $2,100 in tickets.
I
So
don't
the
have.
case
For
you're
about four
referring
different
to,
counties.
Ma'am,
the case you're referring to is out of the 48th District Court. You have to take it up with that.
48th is Bloomfield. You got to go there. Okay? But as it relates in Pontiac, you're all set. So you can stand,
set.
go to that door behind you, other than going to court. Go to that door behind you, push out, and let them know I'm ready for the next person, ma'am.
Yes, ma'am. Have a
Okay?
good day.
You too.
Thank you.
You're welcome.
Mr. Hess, just so you're aware, if you receive a report from us, it means that it has not been adjudicated. We don't do reports if they have been. So if you get a report from us, you know it's not shown cause for whatnot.
Okay, thanks, I appreciate it.
Oh, okay. All right. Good morning, ma'am.
Morning.
Okay, please let me know your name.
Jacqueline Pisinski.
Okay. I'm going to change your name here. Mr. Hess, have you had an opportunity to speak to Ms. Pisinski?
I have not.
I can place you in a breakout room if you'd like.
Yes, please. Thank you.
Okay, I'm going to place you in the breakout room with your court-appointed counsel. Ma'am, you and the two of you are going to talk about your case, and then you're going to come out and have a conversation with me. Mr. Hess, I've set the timer on this at 7 minutes. If you should need more time, just let me know. I'll set it at 8. Open it,
Thank you.
and I'll move
thank you.
her. Okay, so room 1, and Mr. Hess, room 1. There you are.
Thank you.
Mm-hmm.
Your Honor, I just wanted to make sure you knew I was here for the Hardman and Whley matter.
I do. I spoke to your detective, as well as I spoke to Mr. Colo this morning when I was trying to
Great,
find
I
you.
realized I didn't tell you when I logged on, so
It's okay.
I'm here.
Okay, thank you. Good morning, Miss Vivian.
Good morning.
It's gonna.
Still morning.
Good morning.
Yes.
I've got a interesting docket. That's what we call it, right? So it's gonna be a minute before your client comes up. But did you have an opportunity to speak to them?
No, I
Okay.
just logged on, but you know.
Then
I
I'll
did
put
see
you in a
this
breakout room.
defendant-
Go
Okay,
ahead.
I did this defendant in the jail yesterday.
You did? Okay. Well, what I can do though is when they bring him up, I'll put you in a breakout room so you can talk a little bit more. And he's charged with, let's see, a domestic violence.
Okay,
Okay.
yeah.
All right.
So, who will his attorney be today?
His attorney will be Mr. Hess, but he's in a breakout room right now with another defendant.
Okay.
Okay?
All right,
And
very
then
good.
just so
Okay,
you
fine.
know, I'm not sure what view you have, but just so you know, we do have members of the media in the Zoom and in the courtroom, just so you know.
Oh,
So I'll
okay.
need, so when I get ready to do the address, I'll just need you to email or call the clerks to give me that information. Do you know what I
Okay.
mean?
All right. Yes.
Okay, thank you.
Or would you want me to put it in the chat?
Let's see, do I have my chat open?
Oh, I don't even see it.
I don't
Okay,
see it.
never
I don't
mind.
see a chat, and most times. Okay,
All right, very good. Thank you.
thank you. All right, what was I doing? Oh, this. Okay, I'm closing the breakout room, Mr. Hess.
Magistrate, this is Attorney Hensford back.
Okay, all right. Thank you, sir. I'm closing the breakout room now. Okay, Ms. Pisinski, we're calling the case of the state of Michigan versus Jacqueline Michelle Pisinski. Thank you, ma'am. Sir, 250755FY. Today's date and time set for a regular arraignment. Appearances for the record, Mr. Hess.
Edward Hess on behalf of the defendant. Ma'am, please state your name for the record.
Jacqueline Pisinski.
Okay.
Thank you, Your Honor. I've reviewed the charges and maximum penalty of Ms. Pisinski. At this time, we'll waive further formal reading. She pleads not guilty. We ask the court-appointed counsel be appointed for her. Thank you.
Okay, thank you. I'm going to enter a not guilty plea on behalf of your client. Court-appointed counsel is granted. Ma'am, your matter is a felony. As such, it's been assigned to the Honorable Judge Gross. Your first of two hearings that are associated with your felony, the first will be heard on June 17th. 2025. That's going to be at 1:30 p.m. on Zoom. It's called a probable cause conference. The second hearing, which is called a preliminary exam, it will be held on June 24th, 2025, and that's going to be at 9 a.m. in person. Do you understand that, ma'am?
Yes, I do, Your Honor.
Now, ma'am, as it relates to your address, the court doesn't have one for you, and court does not have one for you. Can you give us a good mailing address, ma'am?
Well, I just moved to Pontiac. Can I give you my mom's address?
You sure can.
Okay, it's 8076 Francine Street.
Francine.
Correct.
And it's where? Warren?
Yeah.
Okay.
48089.
Okay. 48089?
Yes.
Okay. And can the court have a phone number, please?
586
Mhm.
453 3555.
453-3555. Got it.
Yes.
Ma'am, sir, as it relates to bond, Mr. Pretrial Services.
Real quick, Your Honor, would you mind rereading the case number?
It is 250755FY.
Thank you.
Thank you.
The defendant was not able to be interviewed due to behavior issues at the jail. Therefore, we have limited background information. According to record, she's a 44-year-old female. The listed address as indicated. She does have warrants out of 36, 37, 42-2, and 51st District Court. She does have a history of failing to appear. She simply indicated she has a history of violence. Much of her criminal history is traffic related, with a significant history of failing to appear. There are a few non-traffic offenses. One's a violation of probation out of the 42-2 District Court. She's currently before this court on a violent felony matter. The alleged victim is listed as Robert Cuckway. We were not able to reach him for a victim statement. The incident did occur at the Stevens Court address in Pontiac. According to records, he has a listed address in Roseville. However, it does seem likely that he resides at the Stevens Court address. And that police report indicates that they do have children in common. Given the information available and stated, release on recognizance is not being recommended. We would recommend pretrial supervision, no firearms or other dangerous weapons, no assault or threatening behavior, no contact with the alleged victim, no return to the 22 Stevens address in Pontiac, and she already provided a valid release address, so I'd strike that from them. Thank you.
Thank you. Defense counsel.
Yes, thank you. To begin, my client does reside at 22 Stevens with 4 children. The alleged victim does not reside there. So we would respectfully ask that she not be prohibited from going to that address. She understands it's likely that the court will impose a no contact order with Mr. Cuckway, and that's something that she plans to abide by. She said she had no problem abiding by no contact order while the case is pending.
Okay, so
she does.
Go ahead.
Yes, ma'am. She does receive government benefits both for herself and for the children. That's how they're supporting themselves right now. She does work as a waitress when she's able to work right now. She's simply not working. I understand that she's got warrants out of other jurisdictions, but respectfully, while this case is pending, her goal is to get back to her children. She doesn't know who's, I guess, watching them right now, hopefully a family member, but I would respectfully ask that she be able to cognizance, understanding that if the other jurisdictions have pickups, that she might be taken to another jurisdiction before being released. Thank you.
Okay. So, counsel, are you saying that Mr. Cuckway is not living at the 22 Stevens address?
Yes, per my client, correct. She resides there with 4 children, but he does not reside there.
He's not residing, spending the night. Does he have a key?
No.
No. Okay.
I let him come see the kids because we obviously have 4 together.
Okay.
It was a visitor. Yes.
Okay, as it relates to the bond, court is going to impose, we're going to do a $1,000 personal bond. However, personal bond ma'am, means that you don't have to post any money. However, there are conditions on this bond. One of which is going to be pretrial services supervision, no contact with the alleged victim. The alleged victim is identified as Robert William Kirkway. No assaultive behavior, ma'am, no firearms, no dangerous weapon. GPS tether prior to release, that's going to be the steel band type. And then I'm going to strike the no return to Stevens because there's been an indication by your counsel that the defendant is not, or that the alleged victim is not living there. So I'll strike that part about living there.
Your Honor, do you want to verify what his address may be? I have an address in Roseville. I don't know if she wants to say that.
The address that you know of him staying in Roseville is what, Miss ma'am?
It's near, off of 12 Mile and Gratiot in an apartment, but he just got a new apartment that he was supposed to move into yesterday at 9 in Gratiot, and I don't know what that address is. I know his mom's address is, I can't think of, 12 in Gratiot, basically.
What city?
Roseville.
So pretrial services, we're going to say the Roseville address.
Okay, I'll just provide the one that we have is 19606.
19606.
Jerome Street, Jerofd.
Okay.
Apartment 125 in Roseville. 48066.
48066. Okay. You have any questions about your bond, ma'am?
I'm kind of confused. So I'm staying till the 16th, or what am I doing?
Okay, so the next date is the 17th. You can get released on a personal bond from us. However, I'm gonna need you to get on a tether prior to release. I think they charge you maybe, I don't know, but they'll be able to help you in the jail to determine what the tether amount is. So you don't have to post any cash for this bond, but you will need to be on a tether, ma'am. This is assaultive behavior case. We're releasing you back to the address based upon your word that the defendant doesn't live there, and you have prior assaultive behavior and other outstanding warrants. So for that reason, the safety of the community, to ensure that you're here at your next appointed time, this is the bond.
I got it.
You got it now?
Okay.
Okay.
Thank you.
You're welcome, ma'am. If you're all set, you can stand and go to that door, push out, let them know we're ready for the next person.
Okay. Does it? Oh.
It pushes, yeah, it does.
Hey, no, they want the next person.
Good morning. Can you tell me your name, please?
Tamisha Powell.
Okay. Ms. Powell. Counsel, have you had an opportunity to speak to Ms. Powell?
I'm checking my list. No, I have not. Sorry.
Okay, then I'm going to place you in a breakout room with Ms. Powell. Ms. Powell, I'm going to put you in a breakout room with your lawyer. You're going to talk about the case, and then you'll come back out and talk to me, okay?
Okay.
All right.
Thank you.
You're welcome.
Thank you, Madam Chair.
Uh-huh.
Magistrate. This is Attorney Hess at return.
Thank you.
Aye.
All right, let's see. Close out the breakout room. Calling the case of the State of Michigan versus Tamisha Powell. This is case 250756SM. Today's date time set for a regular arraignment. Appearances for the record, please.
Thank you. Good afternoon, Magistrate. My name is Edward Hess. I'm representing the defendant for today's proceeding only. Ms. Powell, please state your name for the record.
My name is Tamisha Powell.
Okay.
Thank you. Your Honor, I've reviewed the charges of maximum penalty with Ms. Powell. Will waive further formal reading from the court. Ms. Powell pleads not guilty, and she's respectfully requesting court-appointed counsel. Thank you.
Okay, I'll enter a plea of not guilty on behalf of your client. Court-appointed counsel is granted. Ma'am, your case is a misdemeanor. It's been assigned to the Honorable Judge Whley. Judge Whley can next hear this case on July 1st, 2025. That's going to be at 9 a.m. on Zoom. Let me see if I can find an earlier date. Yes, Madam Clerk.
Can I start taking
Give me
files?
1 second. You can. There
Anything in here?
and here. Tab these two. Thank you. Judge Whley case, July 1st, but let me see if I can find an earlier date. In the interim, ma'am, while I'm looking for that, we have you listed at 90 Virginia in Pontiac. Is that still a good address?
Yes, it is.
Okay, and can the court have a phone number, please?
It's 248 812 4384.
4384.
When I get out, I'm gonna pay my bill. Okay. 248 812 4384.
Thank you.
It's probably off right now because I wasn't able to pay my bill today, but I'm gonna pay it as soon as I get out.
Okay, and then, okay.
Can
So
I
this
give
is
you
the
an
number.
extra phone number?
Oh, yes, you can.
Okay, 248 924 0945, and that is my daughter's father number. He will always be able to get me a message just in case I'm not able to pay my phone bill right away.
Is he Jesse Poinier?
No, I don't have kids that Jesse. This is Jerome Taylor. This is my daughter's father. I have no kids with Jesse.
Okay. Jerome Taylor. I have it, ma'am. As it
Okay,
relates
thank
to,
you.
thank you. As it relates to bond, pretrial services.
Thank you. The defendant was interviewed. Her information was not able to be verified. She's a 43-year-old single female, 4 adult children, and 1 minor child, indicated living at the state address for 5 months with a roommate, working full-time for Diversified Pontiac as a janitor for the past 5 months. She has been convicted of 2 or more violent charges. She does not have a documented history of failing to appear for set court dates. She was on parole at the time of this incident. It should be noted that she was on parole for violent felonies at the time of this incident, and there is an MDOC detainer in place. However, given the other information stated, the fact that it's a misdemeanor charge, as well as the other supportive information, we're recommending release on her cognizance with the conditions of no firearms or other dangerous weapons, no assault or threatening behavior, no contact with Jesse Portier, no return to 10 Fireside Lane in Pontiac. Should also note they appear to have been dating for 5 months, no children together. They do not reside together. Thank you.
Thank you. Defense counsel.
Yes, thank you. I agree with the recommendation.
Portier, pretrial services, is it Portier? Is there a T?
Spelling.
The player is POIRIER.
Thank you. Ma'am, because you were on a detainer, there is an MDOC detainer. Hold on.
Yes.
IER. The court is not going to be inclined to give you a personal bond on this case. This case involves assaultive conduct. The case that you were on parole for also, so We're not doing a personal bond. However, the court will enter a bond of $10,000, cash, surety, 10%.
So it'll be $1,000?
Yes, ma'am. But that bond can be revisited when you next see Judge Whley. Wait a minute. Defense counsel, you said this defendant is employed?
I am employed, but I think
I need to talk to you. I need to, Ms. Powell. Ms. Powell, take a breath. Take a breath, okay? Mr. Hess, you said your client is employed?
Yes, she's employed. She works as a janitor and also delivers vehicles for a car dealership. She's paid in cash for both jobs.
In pretrial services, even with the parole detainer, you're recommending release on personal recognizance?
Yes, Your Honor, our policy is to go based off of all the other information regardless of a detainer or not.
Okay. Court will do a $1,000 personal bond. However, there are conditions to this bond, ma'am. No contact with the alleged victim, no firearms or dangerous weapons, no further assaultive behavior. We are going to do a GPS tether, ma'am, prior to release, and then no return to 10 Fireside Lane, Pontiac, Michigan. Because I did the tether, I'm going to do pretrial services supervision. That bond can be revisited once you see Judge Whley on July 1st. Because that court date is so far away, I don't have an earlier one, then the court is inclined to do this bond. Do you understand the terms of the bond, Ms. Powell? So you don't have to post, you don't have to post any money, but you do need to get that GPS tether before you get out. So I think it's
So
like
I don't have to pay $1,000?
no, you don't have to pay the $1,000, but you do have to get a tether because we want to know where you are. 135, something like that. They'll tell you in there.
I can get that,
Okay,
yeah.
they'll tell you in there. Okay. Do you have any other questions, ma'am?
No.
Okay, then you can
So
stand.
I have one more question.
Okay.
So, like, they gonna come give me a tether here?
Yes, they're gonna give it to you before they let you out. They'll come to you.
Okay.
Okay, so talk to the deputies when you get out there. They'll tell you who you need to contact. You can go to that door behind you, push out, and let them know we're ready for the next person, okay?
Okay.
Okay.
Thank you.
Good luck, ma'am.
Okay, thank you.
Don't violate that bond.
I'm not.
Okay. Okay, go ahead.
Okay. I'm done, sir.
Hello.
Hello, good afternoon. Can you tell me your last name, please?
It's Coates.
Okay.
Yes, ma'am.
Okay, let's see. Let's see. Okay, Mr. Hess, have you had an opportunity to speak to Mr. Coates?
I have not.
Okay, then I'll place you in the breakout room. I'm going to place you in the breakout room with your lawyer. He's going to talk to you about your case. I've got one count of domestic violence, and then you'll come out and talk to me, okay?
Yes, ma'am.
All right. There you go.
Thank you. We're back in history.
Okay, thank you. This is calling the case of people of the state of Michigan versus Quincy Latrell Coates. This is case 24-1862-SM. This is date and time set for a bench warrant. And this is not the first. This is the first appearance, but this is not the first bench warrant. Mr. Hess.
Thank you, Edward Hess, on behalf of Mr. Coates, who this afternoon is speaking. Mr. Coates, please state your name for the record.
It's Quincy Latrell Coates.
Your Honor, respectfully at this time, Mr. Coates pleads not guilty. I will waive any further formal reading. I've reviewed the charges of maximum penalty with my client. He's requesting a court appointment.
Okay. I'm going to recall the bench warrant, enter a not guilty plea on the behalf of your client, and I am going to appoint court-appointed counsel. Sir, your case is a misdemeanor. It's assigned to the Honorable Judge Walker. The next date is going to be a pretrial hearing, and it's going to be set for June 25th, 2025 at 9 a.m. on Zoom. Do you understand that, sir?
Yes, ma'am, I do.
Sir, we have an address for you, 25 South Edith, number 2, Pontiac, Michigan, 48342. Is that a good address?
Yes, ma'am, it is.
Okay, and then can the court have a phone number?
Yes, ma'am, 313-221-3888.
3883. Thank you.
Yes, ma'am.
As it relates to bond, pretrial services.
Thank you, Your Honor. Defendant was interviewed. This information was verified by his ex-girlfriend, Iris Edwards. He's a 32-year-old male with no children. He's been living at the stated address for the past year and 2 months. He's a high school graduate. He's been unemployed since December of 2024. Does have a history of failing to appear. He does not have any prior violent convictions. With regard to the most recent warrant, it appears he failed to appear for this matter on May 20th of this year. However, I have verified he's been in custody at Oakland County Jail since April 30th. So I'm not sure why he wasn't to the list, and it wasn't his fault for failing to appear on that matter. The alleged victim in this matter is listed as Shavita Dean. We did speak with her. She denied being in fear of the defendant, denied anything physical took place, will not participate in the legal process. He does have one other matter that was holding him with the projected release date. The 48th District Court was today. So with that matter resolved, we are recommending release on recognizance with the conditions of no alcohol or controlled substances, no firearms or other dangerous weapons, no assault or threatening behavior, no contact of any type with Shavita Dean, and no return to her address at 536 Cameron Avenue in Pontiac.
Okay. Pretrial services, I have, and I'll get to you, Mr. Hess. I have that it was scheduled for a pretrial on January 16th, 2025, and that on that day the defendant failed to appear, and it was adjourned. They adjourned that pretrial to February 13th, 2025 at 9:15. Bond was continued, and on February the 13th, 2025, defendant failed to appear, and then there was a warrant, and then it was scheduled for pretrial on 5/13, and that's when you're saying the defendant was in custody from April 30th, correct?
That's correct.
Okay, thank you. Pretrial services as defense counsel as it relates to bonds, sir. What can you tell me?
Yes, thank you. My client says he would have no concerns with abiding by any potential no contact order, both not contacting Shavita Dean and also not going to her home address. I believe the pretrial also recommended not have any contact with Ms. Dean's children, which is fine. And beyond that, my client's out of work, but he says he's looking for a job. So I'll respectfully ask to be released.
Okay. Court is not going to give a personal bond just simply because personal bonds have been granted a couple of times where we couldn't make it. Court does allow for the fact, though, that the defendant was in custody and was not brought over. So the last hearing was not his fault. For that reason, we're going to set the bond at $250 cash with the following conditions of do not, no alcohol, no drugs without a prescription, no firearms or dangerous weapons, no assaultive behavior, no contact of any type with Shavita Dean or her children. Those are not your children, correct, sir?
That is correct.
Okay. And then do not return to 536 Cameron Avenue in Pontiac. Do you understand the terms of your release, sir?
Yes, Madam Chair.
Okay, thank you. If you don't have any questions, then you can stand. Go to that door behind you, sir. Push out and let them know we're ready for the next person. And good luck to you, Mr. Coates.
Thank you. Thank everyone. Have a good day.
You too, sir. Good afternoon, sir. You tell me your name, please.
Jamarial Hardman.
Okay, Mr. Hardman, let me change your name here. Counsel, have you had an opportunity to speak to Mr. Hardman yet?
I have not.
Okay, then I'm going to place you in a breakout room. Mr. Hardman, I'm going to place you in a breakout room with your attorney. He's going to talk to you about this case, and then you'll come out and have a conversation with me. Do you understand that?
Yeah.
Okay, then let me change your name here. All right, I'm opening the breakout room. I'm leaving the 8 minutes on there. If you need more time, counsel, you let me know, okay?
Yes, thank you.
You're welcome.
Excuse me, Your Honor.
Yes,
I
ma'am.
apologize. I just wondered, do you know if Mr. Atacho Gutierrez will go beyond 130?
I don't know if Mr. Ataches Gutierrez will go beyond 130. I'm going to take care of this one. This defendant has a co-defendant,
Okay.
which I'm assuming that they're going to bring in next. And then I can ask them to bring in your client. If it looks like it's going beyond 130, what would you like me to do? Would you like me to have them call someone else, or what?
No, I can still stand by. I would just have to log on to another courtroom on another device, and
Okay.
until I turn the camera on, I wouldn't be available. That's my little
And
code.
that's okay. That's okay. I can take care of that, and I can also ask them to put the defendant. I've got a number. If they sent you a copy of the docket, I can ask them to place that defendant at the end if that helps.
No, I don't want to interrupt
Okay.
your the way you
Okay.
handle your and the way the jail handles everyone. I don't
Sure.
want to mess with that. I just wanted to just kind of let you know that.
Okay.
We could work it out that way.
So
Okay.
if when it comes back, if you're not on camera, I'll call your
Right.
name. If you don't come, then I'll ask them to bring someone else and bring him back. We'll do it that way?
That would be- Yes, thank
Okay.
you. That would.
Thank
and
you.
that would be till after 1:30.
Okay.
Thank you.
I got it. Thank you so much.
Thank you. I'm back for Mr. Hunt.
Okay. Close the breakout room. Calling the case of the state of Michigan versus Jamarial Hardman, This is case 250754FY. This is date and time set for an appearance or for an arraignment. Appearances for the record starting with the people.
Good afternoon, Your Honor. Devin Schultz on behalf of the people.
Defense.
Good afternoon, Your Honor. Edward Hess on behalf of the defendant for this afternoon's proceeding only. Mr. Hardman, please state your name for the record.
Jamarial Hardman.
Okay.
Thank you, sir. Your Honor, I have reviewed the charge and the maximum penalty of Mr. Hardman. At this time, we'll waive any further formal reading by the court. Mr. Hardman pleads not guilty, and he's requesting court-appointed counsel. Thank you.
Okay. Court's going to enter a plea of not guilty. Court-appointed counsel is granted. Sir, your case has been assigned to the Honorable Judge Gross. It is a felony. Because it is a felony, there are two hearings that are scheduled for this case. The first is called a probable cause hearing. It will be held on June 17th, 2025. That's going to be at 1:30 p.m. on Zoom. The second hearing was what is called a preliminary examination. It'll be held on June 24th, 2025. That will be at 9 a.m. in person at the 50th District Court. Do you understand that, Mr. Hardman?
Yes, ma'am.
Okay. Sir, we have an address for you of 111 Thorpe Street, apartment 1 in Pontiac. Is that still a good address?
Yes.
Okay, and can the court have a phone number, please?
248 462 9402. That's my mom. You talking about my number?
That's good. It's a number where court-appointed counsel can contact you to talk to you about your case. Is that the phone number you want us to use?
Yeah.
Okay.
Phone off.
Okay, that's fine. Then that's the number that we will use. As it relates to bond, Ms. Schultz, people first.
Thank you, Your Honor. I want to provide a little bit of information about this case to Your Honor because the people at this time are requesting at least a $150,000 cash surety bond with no 10%. On January 3rd, this week, there was a graduation at the United Wholesale Mortgage Sportsplex in Pontiac, and that was for the Academy of Arts and Technology for Pontiac. Mr. Hardman was in attendance along with his co-defendant, Mr. Whley, and two other unidentified individuals. They walked into the auditorium of the Sportsplex, they took a seat, and they were only inside for less than 10 minutes before Mr. Hardman, Mr. Whley, and the other two suspects approached another group, and Mr. Hardman struck another young man in the head who was in attendance at the graduation. The fight escalated, they were escorted out, another fight began at the entrance of the Sportsplex, and then everybody was taken out into the parking lot. At this point in time, Mr. Hardman and Mr. Whley began to congregate around the vehicle, a Hyundai Elantra. Mr. Hardman at some point walked away from that vehicle where he appeared to be intentionally struck by a Chevy Malibu. He was uninjured and he returned to the group. Surveillance video from the parking lot shows that at that time, Mr. Hardman became in possession of a very distinctive graphic printed with a shark on it backpack, and he was now standing by an open Elantra. The video also shows that at this time, the co-defendant, Mr. Whley, is running back towards the group, now clutching his waistband with a heavy object. At one point in time, his shirt rides up, and you're able to see clearly on the surveillance footage that Mr. Whley has what appears to be an extended magazine sticking out of the waistband of his pants. Mr. Hardman and Mr. Whley run through the parking lot for a brief period of time, and then they enter back into the Elantra. The whole time, Mr. Hardman has possession of this very distinctive backpack. The Elantra drives through the parking lot for a short period of time, and then Mr. Hardman and Mr. Whley exit it again. At this point in time, Mr. Hardman, still with the backpack, and Mr. Whley crouch under and in between some parked cars in the parking lot. They get back into the Elantra and they leave. Less than 20 minutes later, deputies with the Oakland County Sheriff's Department discover two firearms right where Mr. Hardman and Mr. Whley were crouching. They discover a Glock with an extended magazine just on the pavement underneath a vehicle. They also discover the same backpack that Mr. Hardman was in possession of. Inside of that backpack, they find an AR-style pistol and a drum magazine. Both firearms had the capacity to be loaded with 40 rounds of ammunition and were nearly fully loaded, and both had a round chambered. Mr. Whley was interviewed post-Miranda. He admitted to possessing a firearm. He stated that he left it in the car, the Elantra presumably, during the graduation ceremony, and then retrieved it after the incident when Mr. Hardman was struck with a car. Mr. Hardman was interviewed and denied everything and denied that there was a firearm in the backpack. What I want to highlight, for Your Honor, and why $150,000 is justified for bond for Mr. Hardman is that he is, at this time, 70 days into a height of probation term for carrying a concealed weapon out of the Oakland County Circuit Court. That case happened in May of 2024 last year. He was sentenced on March 31st of this year before Judge Rowe, and over the people's objection, Judge Rowe gave him a chance on YTA. And he gave him a chance on YTA with a set of very strict conditions, which Mr. Hardman, not including new criminal conduct, has already continued to violate. He was ordered not to be around known felons. The people have Instagram evidence that he's been hanging out with individuals who are known felons and, in fact, on federal supervised release. He was ordered not to return to a smoke shop where a number of music videos were shot that's located in Sterling Heights. This same location was the subject of a bond motion, one of multiple, during Mr. Hardman's time before Judge Rowe, that he was ordered not to return to explicitly. He was already posted within weeks of being placed on probation in a music video at that same location. On top of that, during the time that Mr. Hardman was pending in circuit court before Judge Rowe, we had multiple issues with bond. There were unauthorized stops. He was on a tether. That didn't deter him from being what he needed to do. He was found in another defendant's phone dump for a separate assault with intent to murder case, looking for where he could get a firearm, and this was during October of 2024, so well into the time that his case was pending. He repeatedly posted images of marijuana, references of selling marijuana, and driving around and not following directives from the court, both District Court, Judge Whley, and Judge Rowe, to engage in meaningful employment, to follow a curfew, and to be where he's supposed to be. The reality is that Mr. Hardman is only 20 years old, and he now is facing his second weapons offense, a second felony weapons offense. Not only this, but he does have a juvenile adjudication for domestic violence. Mr. Hardman has demonstrated time and time again that he cannot and he will not abide by any condition that any court in Oakland County sets for him at any stage of proceedings. He has had his bond increased. He has had a tether on him. He has had very strict parameters on what he can and cannot do. He has been given chances by the court. None of them have deterred Mr. Hardman from less than 3 months into a probationary term for a weapons violation from not seeking out and possessing another weapon. This graduation, Your Honor, was a public event. There was over 1,000 people registered for attendance. Mr. Hardman already disrupted that event with physical violence inside of the auditorium. He is the instigator. This is on video. But not only that, but instead of walking away, instead of leaving after he was escorted out, Mr. Hardman and his co-defendant escalated. They took this a step further by arming themselves, presumably in response to the Chevy Malibu incident. The people are asking for a bond that is going to ensure the protection of the public, that is going to reflect the serious nature of this offense, and that is going to, frankly, protect Mr. Hardman himself. He has shown that he was willing to instantly engage in retaliatory behavior against other individuals who were at the graduation ceremony. He was armed with a firearm that day that had the capacity to shoot 40 rounds. He took that firearm to that location and then armed himself with it after the Chevy Malibu incident. Mr. Hardman is willing to engage in dangerous behavior. He does not care about the collateral consequences of public safety, and no court directives have ensured his compliance while on pretrial release, including a term of YTA probation. So for all of those reasons, I'm asking for at least a $150,000 cash surety, no 10% bond, no tether. Thank you.
Thank you. As it relates to this bond, pretrial services, what is your recommendation? And then I'll get to defense.
Thank you. The defendant was interviewed. His information was verified by his mother, Shed Tweak and Burns. He's a single 20-year-old male with no custody of a 1-year-old child. Indicated living at the stated address for a few months with his grandmother. Appears to be reported being unemployed for, quote, a while. High school graduate, as stated by the prosecutors, on probation at the time of the incident. He's also been on several community-based programs, including the Step Forward program, I can verify that there has been numerous issues of non-compliance while on community-based programming with pretrial and justice services. I can also verify that he's been on tether and has had similar incidents of non-compliance while on tether. I would add to what was stated, in addition to the incident that was suppressed with HIDA, there was one prior incident that the warrant was denied previously. Given all the above information stated, we are not recommending release on recognizance. We will recommend pretrial supervision, no firearms, other dangerous weapons, no assault or threatening behavior, no contact with the co-defendant, Mr. Whley, and a GPS tether prior to release, no return to the location of the incident. Thank you.
What is the location, the address for the location of the incident?
I don't have it readily available. I'm not sure if the prosecutor's office may have it at hand.
Just a moment, Your Honor, I can look it up.
Okay, while you look that up, defense, your rebuttal?
Yes, thank you very much, Your Honor. In considering the bond to be granted in this matter, the court has to consider the protection of the community, their person, and the likelihood of Mr. Hardman returning to court. So, as far as returning to court, I haven't heard about a prior failure to appear history. There's a recommendation in the written pretrial services report for a home confinement tether. I think that's an appropriate condition of release that would be able to satisfy the community safety aspect of release without having to require a high cash surety bond. I will also note some positives for my client. He indicates to me he is in community college. He has been hired for a job at a factory that he would like to start soon. And as a concern, he also does have a medical issue that requires physical therapy. So he is seeking to be released for that reason as well. So I respectfully ask that if the court finds that my client is not a good candidate for release on recognizance, that any bond imposed be a 10% bond with appropriate conditions to include a GPS tether with home confinement, as opposed to requiring a high cash or surety bond with confinement in the jail. Thank you.
Counsel, does your client,
Your Honor.
does your, one second, defense, 1 second, Madam Prosecutor. Defense counsel, does your client own his own home?
I don't believe so.
Okay. People, you had something to say?
Thank you. Yes, Your Honor, I had a very brief response if you'd allow it. I also have the address.
Give me the address.
Location of the graduation. It was 867 East South Boulevard, and that's in Pontiac.
Thank you. Your rebuttal?
Yes, thank you, Your Honor. I want to address two things.
Hold on 1 second. I need 1 second with my clerk. Hold on. Okay.
Just letting you know.
Okay. Thank you. Oh, thank you. Thank you. Your rebuttal.
Thank you, Judge. All right, I want to address two things here. The first being that this isn't a situation where we're worried about Mr. Hardman appearing for a court date. What we're worried about is what Mr. Hardman is up to when he's not appearing in court, and when he thinks the court is not watching, and when he thinks the court isn't able to track what he's doing. He has demonstrated for over an entire year at this point to the Oakland County Circuit Court and to the Oakland County District Court at the pendency of his first case that he will not abide by the terms and conditions set by the court, and that he will only address them when he is brought before the court for a bond motion and thinks that it's going to have a negative impact on him. He has continuously violated, as pretrial services stated, throughout the course of a year. So respectfully, I don't think that the analysis is whether or not he's going to appear for court. The analysis is whether or not we can protect the public now from Mr. Hardman, who has demonstrated that he can and will continue to access weapons regardless of the fact that he has a pending felony probation. I also want to address the argument that home confinement would be suitable to protect the public. In this case, I respectfully disagree. As I stated, the people were in receipt of a phone dump in a separate case, an assault with intent to murder, in about October of 2024, where Mr. Hardman is texting and communicating with that group, talking about sliming his opponents out, talking about engaging in acts of threats or violence with other people in the community, and talking about where to find a firearm. So I think that home confinement does nothing to tell us what Mr. Hardman is saying to other members of the community. It does nothing to tell us about what he's planning. And it really does nothing to prevent the coordination of him accessing another weapon. Finally, I just want to address the point of the medical condition with the physical therapy. Mr. Hardman did raise this issue in June of last year before Judge Whley. This has been brought up multiple times. It was my understanding from every bond motion we've had that that has never been something that was prohibitive of him. In fact, then going to find work and saying he was going to find work when the court told him to. So when we consider all of these things, Your Honor, I think it's clear that at this point in time, Mr. Hardman's behavior is what has Mr. Hardman before the court today. And it is his behavior that is dictating the people's request here for a high cash surety bond with no 10%. The public cannot be protected from him. He will not abide by court orders. And this is a severe set of facts that could have caused serious injury to many people. Thank you.
Thank you. When the court weighs its decision as to what the bond will be, there are a couple things we have to consider. One is the safety to the community. Two is the likelihood of the defendant returning to court. And then also whether or not this defendant will comply with this order. My review of the defendant's record and the complaint in this case indicate that it's not very likely that the defendant will comply with this court's order. For that reason, court is imposing a $250,000 cash bond with the following conditions. Pretrial services supervision. Sir, when you are released on this bond, there's a blue piece of paper that's the size of this. It'll have the instructions for you to contact pretrial services. It will also, you're also ordered to have no contact with the co-defendant, who is indicated as Devin Whley, DEAHVEON Sir, if you are released, you will be placed on a GPS tether prior to release, and that's going to be the steel band tether. And there's to be no return to 867 East South Boulevard in Pontiac, Michigan. Mr. Hardman, do you understand the terms of your bond?
Yeah.
Okay, do you have any questions about your bond, sir? Okay, then you can stand, Mr. Hardman. Go to that door behind you, push out, and let them know we're ready for the next defendant. Thank you, sir. Good afternoon, sir.
How you doing?
Good. Can you tell me your name, please?
Jermaine Maris.
Okay, Mr. Etchen. E-T-C-H-N. Have you had an opportunity to speak to Mr. Etchen, Mr. Hess?
I have, Your Honor. Thank you.
Okay. I'm going to pull your cases, Mr. Etchen. Give me 1 minute, sir. Get them called. I'm going to call all these case numbers, Mr. Hess, but then we'll go through one at a time, okay? Just want to make a record that I have them. All right. Calling the case of people of the City of Pontiac versus Jermaine Maris Etchen. This is case 17OS36110A and B, and then case number 16OS18264A, B, and C, and then case number 23OS09827OT, case number 23OS09827A, this looks like B, and what I just mentioned before was C, and then case number 23OS36107A, case number 21OS06672A, case number 21OS11663ABC, case number 191695OM, and finally case number 230015OM. Date and time set for bench warrant arraignments on most, if not all, and then show cause on a few. I'm going to start with 17OS36110A and B. Get my paperwork to match. A. Okay, one at a time. One at a time. So that case is a misdemeanor, couple of misdemeanors, in fact. One misdemeanor, one civil infraction. In any respect, it's been assigned to the Honorable Jeremy Whley. Sir, it is alleged on these two cases that you failed to appear. Mr. Defense Attorney, appearances for the record.
Thank you, Edward Hess, on the defendant for today's proceeding only. Mr. Etchen, please state your name for the record. Mr. Etchen, please state your name.
Jermaine Maris Etchen.
Thank you. Your Honor, I know we're dealing with, by my count, 15 or 16 cases here.
Yes.
We ask that all bench warrants be set aside. Anything that requires a plea, my client pleads not guilty. Anything where he owes money, we're time served. And we ask that we rebut this court. Thank you.
Okay. In this matter, I'm going to set aside, for all cases, I'm going to set aside the bench warrants. These two, we're going to enter a not guilty plea and do court-appointed counsel for your client.
Thank you.
Sir, these matters, as I stated before, are misdemeanors. They're in front of the Honorable Judge Whley. Monday, Wednesday, Friday. We're going to set these on June 30th, 2025. They're going to be at 9 a.m. on Zoom. Sir, the court needs an address for you.
289 Osmond, Pontiac, Michigan.
Mm-hmm. What's the zip?
48342.
48342. And a phone number?
313-819-0842.
0842. Thank you, sir. As it relates to bond, pretrial services?
Thank you. The defendant was interviewed. His information was not able to be verified. He's a single 44-year-old male with 2 minor children, indicated living at that address his entire life with his aunt, currently receiving Social Security disabilities, completed the 10th grade. He does have pending matters out of 52-3 District Court, as well as warrants out of 37th and 44th District Court. In addition to those before this court, is a significant history of failing to appear, as well as a history of violence. However, given that information, is before the court primarily on traffic-related misdemeanors or other non-violent misdemeanors. Therefore, the author of these reports did recommend release on recognizance. With regard to the traffic matters, a condition of no driving without a valid license. I believe there was some malicious destruction, no return to the location of the incident. Given the significant history of failing to appear, I would at least add pretrial supervision. Thank you.
Defense?
Thank you. I think the personal recognizance is appropriate. I think pretrial supervision is appropriate, especially given the number of cases and the client will need help keeping track of when he's got to come forward. I would respectfully ask for cognizance and no objection to pretrial supervision.
Thank you for your allocution on behalf of your defendant. The court will not be giving personal bond. There are too many cases. There are too many failure to appears. There's driving without a license. And as you stated before, the court is concerned with not only the appearance of the defendant at the next court date, but also we're concerned with the safety to the community. A person driving around with no license, no. In these two cases, these two matters here, court is imposing a $500 cash bond on each. Conditions of no driving without a license, pretrial services supervision if released. And no driving without proper registration. Any additional arguments for bond can be made in front of Judge Whley on June 30th. Looks like 28 prior convictions as an adult. Okay. For the cases ending in 18264, A, B, and C, registration and plate violations. We've done appearances for the record. I'm going to set aside the bench warrant per the request of defense counsel. These cases are also assigned to the Honorable Judge Whley. I'm going to enter not guilty pleas and award court-appointed counsel. So June 30, 2025, is that the date? 9 a.m. on Zoom. Defense, this particular ticket with the 3 counts, court is going to say no driving without valid license, registration, or insurance. Your bond recommendation stands, correct?
Correct.
Same for you, pretrial services?
That's correct, Your Honor.
Okay, $500 bond, cash bond each. Case ending in 8270T. Recalling the Bix warrant. This is a Judge Walker case. Not guilty plea is being entered. Court-appointed counsel is being granted. Judge Walker can hear this matter. Let's see. June 18th, 2025, 9:15 a.m. on Zoom. There's no driving without proper insurance. $500 cash bond.
Clarify, Your Honor, that's the 827C, correct? There's also the A and B.
The 827, I have C. You have A and B, but I don't have them in this file. Let me look for them. Oh, here they are. Yes. We'll do $100 cash bonds on the A and B. Oh, I see what's going on. The A and B tickets are in show cause status. You can have those. The A and B tickets are in show cause status. How long has the defendant been in? How long you been in custody, Mr. Etchins?
4 is the question, Your Honor.
4?
Yep.
Okay. On the A and B ticket, defense counsel, if your client wants to admit that on the B ticket he owes $125 cash, and on the A ticket he also owes $125 cash, court is inclined to order time served. Or if he'd rather, I can set them.
Mr. Etchin will admit he both announced that the last purpose and time served in lieu of the finding.
Okay. You understand what your defense attorney just said, Mr. Etchin?
Yes, sir. Yes, ma'am.
Okay. And that's what you wish to do, is to admit that you owe these funds? And waive your right to a show cause hearing?
Yes, ma'am.
Based upon your admission and waiver of show cause, court is going to impose, you said 4 days, we'll do 2 days Oakland County Jail with credit for 2 days. That's going to be in lieu of outstanding fines and costs. The C ticket, though, you have to go before a judge because it's a misdemeanor. So that'll be the June 18th, 9:15 a.m. Zoom hearing. Case ending in 6107A is a driving while license suspended ticket. It's in front of the Honorable Judge Whley. So we'll keep those same dates of June 30th, 2025, 9 a.m. on Zoom. Term conditions of this bond are no driving without a valid license. We'll do a $100 cash bond. Court is recalling that bench warrant, entering a plea of not guilty, appointing court-appointed counsel. Case ending in 672A, failure, driving while license suspended. This is going to be June 30th. 9 a.m. on Zoom. $100 cash bond. No driving without a proper license. Bench warrant is being lifted. Court-appointed counsel is being granted. Not guilty plea is being entered. Takes care of that one. Case ending in 1663 A, B, and C. This is also a Judge Whley case, so June 30th, 2025, 9 a.m. on Zoom. Recalling the bench warrant. Plea of not guilty, court-appointed counsel granted. $100 cash bond. Conditions of this are no driving without license, insurance, license and insurance only. Case from 2019 ending in 650M. This is a malicious destruction of property case. It is the Honorable Judge Whley's draw. We'll do June 30th, 2025. It's going to be 9 a.m. on Zoom. As it relates to bond, pretrial services.
Same recommendation as with the other matters, Your Honor.
Okay, this was the MDLP.
Yes, we would also recommend the conditions of no return to the location of the incident. Up here is the alleged victim is listed as Chantel Hunter. No contact with her.
Okay, no contact with the alleged victim. We're recalling the bench warrant, entering a not guilty plea on behalf of the client. Court-appointed counsel is granted. Would you like to say something regarding the bond, Mr. Hess?
I'll adopt my previous statement.
Okay. It's no contact with the alleged victim. Alleged victim was identified as Chantel Hunter. No assaultive behavior. And no return to the address of the incident. Judge Whley, June 30th. And then finally, case number 23-00150M. This is also malicious destruction of property, but this case is assigned to the Honorable Judge Gross. I'm going to recall the bench warrant, enter the not guilty plea, award court-appointed counsel, order court-appointed counsel. It's not an award. With respect to this case, 23. This is alleged to have occurred this is injury to property or injury to person? Oh, the window. Okay. So court's going to order no contact with the alleged victim. The alleged victim is identified as Tamika LaShawn McGee. This injury to person to vehicle. This is going to be $500 cash bond. No contact with the alleged victim. No return to the address of the incident. No assaultive behavior. Because it's a Judge Gross case, pretrial is still a misdemeanor. Pretrial will be scheduled for Wednesday, June 25th, 2025. That's going to be at 9 a.m. on Zoom. Do you have any questions, Mr. Etchen?
To be honest, ma'am, I got a lot of questions. I can only ask a few.
Okay, do you have any questions relating to the bond or when your next court date is? Because this court doesn't handle the actual, I'm not handling.
I just want to know what the bond is.
Oh, the total of the bond?
Yeah, I didn't mean to cut you off.
It's okay. Okay. Hold on. Oh, she took one with her. Pretrial services, did you write them down?
I've been doing my best, Your Honor, yeah.
Okay, you got a total?
Well, out of the two initial, 500, and then we said how many total counts was there?
I don't have all the files in front of me. Let's see.
At the beginning, Mr. Hess indicated, I think, did you say 18?
How many did you say, Mr. Hess?
I was up to 15.
15.
At least 15.
Okay, so, all right, well, let's just find out. So this is 5, so that's 1,000. There. Then, so we got 1,000, and so another 5, so that's 1,500. And then this one was 695 OM, the 2019 case, the MDO malicious destruction of property.
That was 500, right?
500 cash. So now we're at 2,000. These were driving. So 2,000 plus 100 is 2,100, 2,200, 2,300, 20. These we admitted, so we're done with those. Plus 500, so we were at 2,200 plus 5 is 27. I got 27 cash, give or take. That's for bonds.
That's for everything now?
That's for the bonds on everything, yes, sir. You do have to come to court because these are misdemeanors. They're not tickets, so it's not like you can just pay them and be done with them. These you actually have to see a judge and a prosecutor on. Okay. Sir, we're all done. You can stand up, go to that door behind you, press out, and let them know I'm ready for the next person. Thank you, Mr. Etchins. Did we lose the jail?
No, the jail room.
I was informed though that there was a fight inside a cell, so one of our people won't be here, Mr. O'Brien, William O'Brien.
Understood.
Okay. Good afternoon. Please tell me your name.
Davian, Whley.
Okay, Mr. Davian. Let me change your name here. Deahbeon. Is it changing? What is going on? No. Let's see. Name. Deahbeon. Mr. Hess, if you had the opportunity to speak to your client, you're on mute.
I have not had the opportunity.
Okay, then I'm not open the breakout room. You and your court-appointed attorney, Mr. Whley, are going to talk in a breakout room where we can't hear. Then you'll come out and we'll take care of your case. Okay?
All right.
All right. You done? All right.
Yes, ma'am.
Closing the breakout room now. Okay, calling the case, people of the state of Michigan versus I'm gonna mess up. Davian Whley. This is case 250753FY. Date and time set for appearances. Appearances for the record. People first.
Good afternoon, Your Honor. Devin Schultz on behalf of the people.
Good afternoon. Defense.
We're counsel for Mr. Whley for this afternoon's proceeding only. Mr. Whley, please state your name for the record.
Davian Whley.
Thank you, Your Honor. I've had the opportunity to review the charges and maximum penalties of my client. This time will waive a further formal reading by the court. My client pleads not guilty and he's requesting court-appointed counsel.
Okay, thank you. I'm going to enter a not guilty plea on behalf of your client. I am granting court-appointed counsel going forward. Sir, your case is a felony. It's been assigned to the Honorable Judge Gross. There are 2 hearings that are coming up. The first is called a probable cause conference. It will be held on June 17th, 2025. That's going to be at 1:30 p.m. on Zoom. The second hearing is a preliminary exam. It'll be held on June 24th, 2025. That's going to be at 9 a.m. in person. Sir, we have an address for you of 555 East Pike Street in Pontiac. Is that still a good address, Mr. Whley?
Yes, ma'am.
Okay, and then can the court have a phone number?
201 8611.
8611. Thank you, sir. As it relates to bond, people.
Yes, thank you, Your Honor. I am not going to belabor the point of all of the facts because I know Your Honor is familiar with them from Mr. Hardman's arraignment just moments ago. But what I want to highlight for Your Honor is that Mr. Whley is on video on June 3rd after being escorted out after this fight broke out at the ATAP graduation with a firearm with an extended magazine in his waistband. This is visible on the surveillance video. That same firearm is recovered less than 20 minutes after Mr. Whley is observed crouching down in between vehicles after presumably ditching the firearm. And it turns out to be a Glock with an extended magazine. There's a round in the chamber and it has the capacity to hold up to 40 rounds. If I recall correctly, it had 38 rounds in it at the time. This gun was ready. It was loaded. It was good to go. Mr. Whley was interviewed in post-Miranda. He did admit to possessing that firearm. He admitted that he did not bring it into the graduation, but instead that it was in the car, the Hyundai Elantra that we discussed when we were going over the facts previously. He stated that he went and grabbed that gun after the incident where his co-defendant, Mr. Hardman, was struck by the Chevy Malibu. But I want to point out something else, to Your Honor, which is that Mr. Whley also told investigators in this case that he had that gun in the car and went to the graduation knowing there would be people there he didn't like. And so what I want Your Honor to take away from that is that in a situation where Mr. Whley believed there were going to be people that he didn't like, didn't get along with, possibly could have a confrontation with, he brought a loaded weapon with nearly 40 rounds in it, and he had that ready to go. Mr. Whley is only 19 years old. He's already before the court for multiple weapons violations. He also has a juvenile adjudication from only 2023 for an armed robbery and a felony firearm. And it's my understanding that the facts of that case arise from a robbery of a weed dealer, where a firearm was not only displayed, but in fact fired off into the sky during the course of the robbery. Mr. Whley was sentenced to what I understand to be the most restrictive juvenile adjudication. He was dispositioned and sent to the Boys Treatment Program. He successfully completed that program. He was only 18 and a half at that time. But Your Honor, as you can see, the completion of that program, having a very, very serious, what would have been a capital case had he been an adult, felony firearm, armed robbery case, did nothing to deter Mr. Whley from getting out. When he turned 19, he again had access to firearms. He had a firearm. He brought it to this graduation, and his conduct has not changed. So for all of those reasons, I'm again asking Your Honor for at least a bond of $150,000 cash. I don't think that a tether is going to be appropriate in this case. This is a situation where, again, this was a public event where Mr. Whley, for whatever personal problems he had with people attending there, decided to bring a high-capacity firearm. He is a danger to the public. He's demonstrated that he would be willing to engage in retaliation by immediately arming himself after the Chevy Malibu incident in the parking lot. He didn't care about the collateral consequences of either a fist fight or then arming himself and attempting to run through the parking lot, presumably in the direction of the Chevy Malibu. Mr. Whley is a danger to the public. He is a danger to himself. And while this may be his first adult case, it is a serious one nonetheless. And the charges shouldn't belie the seriousness of the actual facts underlying the case. So for all of those reasons, I'm going to ask that you impose a bond of at least $150,000 cash. I do not think a tether would be appropriate to ensure Mr. Whley's behavior in the public or safety to the public. Thank you.
Thank you. Pretrial services, your recommendation?
Thank you. The defendant was interviewed. His information was verified by his father, Lester Whley. He's a 19-year-old single male with no children. He's been living with his father and grandparents at the stated address for 5 months. He's employed full-time with American Axle as a machine operator, high school diploma. He's not currently on community supervision, has a limited criminal history. As indicated, he does have a juvenile history. He's before the court on serious felony offenses, therefore we are not recommending release under cognizance. The author of this report is recommending pretrial supervision, no firearms or other dangerous weapons, no assault with threatening behavior, no contact with his co-defendant, Jamarial Hardman, and I would add no return to the UMW Sports Complex at 867 East South Boulevard in Pontiac, and they added a GPS tether prior to release. Thank you.
Thank you. Defense.
Thank you, Your Honor. This young man is gainfully employed, lives in a stable housing situation with his family in Pontiac. I would respectfully ask that following the written recommendation, the Pretrial Services Department for a GPS tether with home confinement, that the court find that a 10% bond would be appropriate if release under cognizance is not appropriate. So I'd ask for a 10% bond and GPS tether with home confinement. I think that would serve the interests of the allow the court to ensure my client's location and to ensure his return to court. Thank you.
Thank you. You have a rebuttal, Ms. Schultz?
Yes, briefly, Your Honor. I just want to highlight that by all accounts, Mr. Whley had everything going for him. He was gainfully employed. He completed his services for the armed robbery when he was a juvenile, and he had stable housing, and yet he still possessed a Glock with an extended magazine and brought it to a public event. He still armed himself with it. He has demonstrated that he is a danger to the public, and my request still stands, and I would ask for no 10%. Thank you.
Thank you. Court has to take into consideration the safety and well-being of the community, as well as whether or not the defendant will appear. And then in addition to that, this court likes to consider the actual allegations and whether or not this defendant will comply. This is an incident where the defendant, you said at 18 and a half, successfully completed a juvenile program where he avoided incarceration for armed robbery and felony firearm, completed a number of courses, and it appears once he was released, he was gainfully employed, placed into a stable household, and now we have these allegations pending involving dangerous weapons, yet again in a public place this time. Court is going to impose a $200,000 cash bond. Should you make that bond, sir, you're going to be supervised by pretrial services. They're going to give you this blue piece of paper. On it has the pretrial services phone number. In addition to that, you're to have no contact with the co-defendant, indicated to be a Jamarial Hardman, no further assaultive behavior that includes while in jail, no firearms and or any other dangerous type weapons. Should you be released, we're doing GPS tether, steel band, no return to the address of the alleged incident, which has been identified as 867 East South Boulevard in Pontiac, Michigan. Mr. Whley, do you have any questions concerning the terms of your bond?
No, ma'am.
Okay. If you don't have any questions, sir, you can stand, go to that door behind you, push out, and let them know we're ready for the next person.
Thank you, Your Honor.
Thank you. Court is taking a brief 4-minute, 2-3 minute break. I will return.
Thank you.